My application. Lordship, allegation 420, 406, 506 of the Indian Penal Code.
420.
Yes, Lordship. The complainant allegation is, Lordship, the complainant paid 2 lakhs as advance to purchase the land out of 5,50,000, Lordship. But he did not register the deed. Actually, Lordship, I have sent the advocate my notice, Lordship, to pay the rest amount and took registration. But he failed and then he lost this complaint, Lordship. Lordship, advocate letter sent on 6/5/24, and after getting that on 25th, he has lost the complaint.
Yes, Mr. Right?
But thrice 41 and notice was issued, he did not comply.
All right. Petitioner contends that this is a civil this is a civil dispute, and he has been falsely implicated. There was no intention to defraud implicated. In spite of notice to pay the remainder sum, complainant failed to comply with the conditions of the agreement. There is no deception on the part of the petitioner. Learned public prosecutor contends petitioner failed to respond to notice under section 41 capital A CRPC. Was it 41 capital A, or your
Yes, ma'am.
notices were under
ma'am.
section
41
35?
No, 41 capital.
41 capital A CRPC. We have considered the materials on record. Petitioner contents notice was issued upon the de facto complainant to pay remainder of the sale consideration, but he failed to do so. It is doubtful whether petitioner had dishonest intention from the inception of the transaction to defraud the victim, to defraud the complainant. Under such circumstances, we are inclined to grant anticipatory bail, however, subject to condition, meet investigating officer once in a week. Next.
42, I am for the petitioner. Case is under section 447, 323, 325, 354B, 435, and 34. And 31 are S, R and S, schedule class and schedule type, Prevention of Authorities Act, my lord. But one is, my lord, but kindly see, my lord, the written complaint.
How this will be maintainable?
By my lord, not attracted this, my lord, section.
Why?
My lord, kindly see, my lord, the written complaint.
Hmm.
The complainant made complaint on behalf of the local community, not individually, my lord. Kindly see, my lord, please.
So,
That's all in my reading, my lord. I see the Sagurika Sajan Sampoda with the Agduli Sampoda Hari Sampoda Goto Sapcha 2024 তারিখে রাত্রি 8টা নাগাদ কালী
yes,
পূজা
you
করলে
don't allow the members of the community
Yes.
to perform
Communi-
Kali Puja, and that is not a violation of the Scheduled Castes and Scheduled Tribes Act.
But, but,
The complaint.
kindly see, my lord, the only my lord, the section of the victim, my lord. And see the I am reading just now, my lord.
Kindly see the 164 statement of the
I am reading, my lord. Victim means any individual who falls within the definition of the scheduled caste, scheduled tribe, and clause
Page 21, my lord.
section 2, my lord. And who has suffered or experienced physical and mental pain, because he is made complaint on behalf of the community, scheduled caste community, my lord.
Because he is a member of the community.
Yes, my lord, that
and
is true.
therefore he is entitled to maintain it
Well,
for himself
This-
and others.
It is totally political matter. This is a totally political matter, my lord. Well, let them say 161. They are clearly stated, my lord. That is a political matter, my lord.
Kindly see page 21.
That is, please let us help you. Officer in charge, so and so shall notify the de facto complainant with regard to pendency of the proceeding and his right to participate therein. Petitioner shall amend the cause title and add de facto complainant as a party responding. De facto complainant shall also be intimated of his right to legal assistance through High Court Legal Services Committee. Copy be served upon so and so. 1B.
I'm grateful, my lord. My lord, kindly one week, my lord, 10 days time. Next week I will not have it.
10 days.
10 days.
Next,
ठीक है एनेरा आले का ओके
Hello, এটা দেবে নাকি? One people in the meantime, no.
Yes, my lord, 326, my lord. My lord, 326 of the Indian Penal Code, my lord, there are 4 petitioners before your lordships, my lord. Case and counter case is there, and there is an existing title suit pending, my lord. The dispute, my lord, is with regard to possession of land, my lord, which was owned by the elder brother of the petitioner numbers 2 and 3.
Cut injury or grievous injury.
Our
petitioner contends that there was a dispute over property between the petitioner and the de facto complainant. Civil suits are pending. They pray for anticipatory bail, and a lawyer for the state opposed the prayer. We have considered the materials on record,
There are statement of eyewitnesses also.
injury as well as including the injury report. The injury is not on a vital part of the body. Full stop. Possible injury is not on the. There was there is long-standing civil dispute, and suits are pending inter se. Under such circumstances, we are of the opinion custodial interrogation is not necessary, and petitioners may be granted anticipatory bail. Meet investigating officer once in a week.
I'm deeply.
Next,
Madam, for the petition, there's a love relation between the victim and the one Akash. Victim fled away. Thereafter, the Akash committed suicide. The present petitioner is the father of the victim born.
The present petitioner is directly linked with the kidnapping of the minor girl. The minor girl has not yet been recovered.
next.
45 about the petition, lordship. Lordship, allegation against the petitioner under section 126, section 2, 107, section 2, 118, section 2, 109, 151, section 2, 302, 3, section 5 of the BNS, lordship. Land dispute, lordship, between the parties, lordship, main allegation against one Jani Sheikh, lordship. He arrested, subsequently grant bail by your lordship, lord. Lordship grant bail, one of the co-accused, one Jani Sheikh, lordship, page 9, lordship. And charge sheet submitted, lordship.
We have considered the materials on record. Co-accused has been granted anticipatory bail.
Bail, lordship.
Has been granted. Principal accused has been granted regular bail. Keeping in mind the extent of complicity of petitioner in the crime, we are of the opinion custodial interrogation for progress of investigation is not necessary, and he may be granted anticipatory bail. Hello.
341, 323, 308,
Not
308 and 34 of the Indian Penal Code. Lordship, charge sheet already submitted and other FIR name accused person are on bail by the learned court below.
tomorrow. Next.
May I please, your lordship? Well, the allegation of section 341, 326, 307. Well, it has been alleged that while she was coming on the way to matrimonial home, she was assaulted and attacked.
What is the nature of injury?
Not given, but there are 10 stitches actually. Told by in a 161 statement. Report 25-26. First she was taken to Raidigi Hospital, then she was referred to Diamond.
How are you related to the victim?
They are neighbors also.
Neighbors.
Neighbor.
Neighbors.
In injury report, she says by relatives.
No, that's wrongly written like this. But we page 4 also can you see page 4? And there were neighbor in the statement also.
No, she was alone. She was coming.
And from the back she was assaulted with a
The
cutter.
child was there.
It's 20 lordship. It's a photograph.
Surrender. Petitioner contends that he has been falsely implicated. He prays for anticipatory bail on a lawyer for the state opposed the prayer. We have considered the materials on record. Statement of the petitioner implicates the statement of the petitioner shows the victim shows that petitioner used to make indecent proposals to her on the fateful day. She was assaulted, resulting in serious injury on her head by a sharp cutting weapon. In view of the aforesaid incriminating materials, we are of the opinion this is not a fit case to grant ransom. Next. मेरा फीलिंग है वो आफ्टर Next.
My lord, I appear for the petitioner, my lord.
Lordship, I am for the de facto complainant.
My lord, this is the case under section 498A, 302 and 34 of the Indian Penal Code, my lord. The other co-accused have been granted, my lord, anticipatory bail. My lord, there is the, my lord,
वो नहीं.
114 is the attachment.
हम उनका क्या है? Next.
So, my lord, this is a case under section 498A, 302 and 34, my lord. I am the husband. The other co-accused, my lord, has been granted pre-arrest bail, my lord. Now, there is a, my lord, a mass petition given by the, my lord, the more than 27%, my lord, who says, my lord, in front of them, my lord, the victim, my lord, tried to commit suicide. And while they are trying to save her, my lord, the body fell down and, my lord, she sustained injuries, my lord. The reason, my lord, she tried to commit suicide, my lord, it is stated in that, my lord, past petition, which is at page 11, my lord, that Milord, the de facto complaint even refused to take her back to her home. That was Milord, the statement made. And Milord, the other Milord accused person have been granted pre-arrest bail, Milord.
Sir, 114 is the application of attachment. 114. 112 and 14.
My lord, if your lordship kindly see, Milord, the statement given by Milord the villagers at page 11, Milord. This category is stated, Milord, that while they were sitting, Milord, the deceased Milord went to her room and Milord tried to commit suicide. In
Forty-six.
no, Milord. As Milord, the de facto government refused to take her back to the Milord home. Not the she was staying with Milord the petitioner.
Lordship, the
Initially anticipated, subsequently, Milord.
12th,
12th of
12th
April.
April 2024,
my lord, marriage on March 17,
2017.
2017, March 2017, and incident occurred April 2024. After my lord 7 March 2017 marriage occurred, my lord, and it was in April 2024, my lord. Right.
Proclamation has already been issued, my lord. Kindly consider this, my lord.
And for the petitioner, my lord, 307, petitioner is the nephew of the complainant.
And the bleeding from mouth, my lord. One day she was admitted. Big problem.
Yes, Lordship, my application. Lordship, allegation under section 447, 323, 326, 354, and 34 of the Indian Penal Code. Petition number 2 is the brother of the complainant. Lordship, dispute regarding property loss, paternal property.
Injury 25, my lord, page 20.
Deep level. Deep level.
What are for the petitioners?
Hmm.
The allegation under section
My lord, for the petitioner, my lord, I'm praying for 1 day's accommodation on the ground of Mr. Ghotak. He had to travel to Bangalore due to his dad's medical emergency, your lordship. So I'm praying for 1 day's accommodation. 1 day's accommodation, your lordship. He will be back tomorrow morning.
Notify the victim. Victim be notified. Officer in charge so-and-so is directed to notify the victim. Matter will appear 1 week.
My lord, the zonal manager of the bank is the complainant, my lord.
Inform him.
He'll be-
Yes.
I am for the petition number 420, 406, 468, 120B of the Indian Penal Code. My lord, a company, my lord, named PR Online Service Private Limited. My lord, they have, my lord, lodged an FIR, my lord, against some unknown persons, my lord, indicating that, my lord, they have transferred certain amounts, hacked their account, my lord, and transferred certain amounts to different other accounts. My lord, now the petitioner before is your lordship is the person, my lord, in whose accounts a sum of rupees 1 lakh initially was deposited by one Minal, my lord, who has been arrested and subsequently released on bail. My lord, immediately when I came to my notice, my lord, that amount is, my lord, in my account, my lord, I immediately refunded that amount to the account of the original, my lord, account holder.
Yes,
My lord,
Mr.
thereafter,
Bhattacharya.
My lord, first initially 1 lakh, there are subsequently 95,000.
95,000.
This total 1,95,000 was rotated from his account, was transferred to his account by this Minal. Minal was arrested, enlarged on bail, but the statutory bail he got because the charge sheet could not be filed. My lord, that is the stage. His 161 statement is there. My lord, 41 a notice was served.
All
My
right.
lord,
Petitioner contends that
September 2023. my lord.
he is no way involved in the conspiracy of hacking the account and transferring funds, hacking the account of the de facto complainant and transferring funds therefrom. As soon as he came to know of the transfer of the funds to his account, he had refunded the same. He prays for co-accused has been granted regular bail. He prays for anticipatory bail. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Petitioner's account was used to park the
Part of the
part of the proceeds of crime. His conduct shows that gives an impression that he was unaware of the transaction, and as soon as he came to know of the transfer, he reverted the same. In such view of
Did
the
not comply with the notice, my lord.
what will the notice do? In such view of the matter, if he complied with the notice, he would have
But he
arrested
would have
him.
shown that he has
He would have. He has done what was most important.
But this
He
refund,
reverted it.
refund is nowhere, my lord. This refund is his story in this application.
So you are saying that it is nowhere. How do you say it is?
Money was received by him, admittedly. But the amount
Correct.
is
We are saying he reverted it. This is what he is saying.
But this reversion is.
Yes, Mr. Ganguly, from
reversion
where are
is
you saying?
Case diary, my lord.
Case diary is not the end of the world, Mr. Bhattacharya. At least we expect you to understand
But
that you might have an incomplete data in the case diary does not make that incorrect. Yes, where is your document of
The
reversion?
document, my lord, he has not annexed, my lord, but
Then
my lord, we have, my lord,
You place
written,
on record?
my lord.
Not today.
কালকে নিয়ে আসুন।
Next.
May please your lordships.
You will not even know. Yeah.
My lord, the case is under sections 319(2), 318(4), 336(2), 338, 336(3), 341, 2, 3, and 5 of the new act, my lord. My lord, one Panchayat Pradhan has preferred an FIR saying that two persons have forged his signature and made a variation certificate. On the basis of such variation certificate, one of the accused persons has gifted the property to the wife of this petitioner, my lord. And the allegation against this
392 is cheating. 319 subsection 2 BNS is cheating, right? Or 318(4) is cheating. 18(4) is cheating.
Billable, 4 is non-billable.
318(4) is cheating. 340 is forgery.
What is
341 and 333.
You are, what is your name?
Dipankar Chakraborty, madam. Allegedly, the property was gifted by the one of the accused persons in the name of my wife. And allegation against me is that I have supported
your
all
wife?
this.
Sujata Chakraborty, he is not the
She
FIR.
is not the FIR named person.
Hmm.
And my lord, there is a political rivalry. The Panchayat is from the Panchayat Pradhan is from the ruling party, and I am from a opposition.
So you are not the owner of the land.
No, my lord.
Then
Sorolabala was the owner of the land. The land was subsequently transferred in the name of Shamoli Panda and Aparna Gain. And both of them subsequently registered this plot of land in the name of Sujata Chakraborty and Kalpana Karmakar.
But how this man is coming into?
I am the husband of the Sujata Chakraborty.
Even police did not, no statement has been recorded of Sarolabala Chakraborty or relative of the Sarolabala Chakraborty. Nothing. Only two statement is recorded.
Of the co-villagers.
They are the co-villagers.
They say that this person helped him.
Sorolabala has died.
It is not reflected from the CD, my lord.
Do you find out
Yes.
what is the transaction? Because they are getting variation certificate. So
Yes.
Sorolabala, whether Sorolabala at all died or not, and who is the person who gave this variation certificate?
The complainant. The
Variation
complainant, man. And his allegation is that his signature was forged. And a
Variation
forged
certificate
variation
is issued
certificate
by
was
forging the signature of the de facto complainant, that is the Pradhan. Pradhan's signature was forged and variation certificate was prepared. And through this variation certificate, these all lands were transferred in their names. In the name of Kalpana and Shamoli.
So there was no inquiry with regard to the certificate. When the certificate was, where is the
There
There are various inquiry reports, my lord.
where is the certificate?
Page 16 and 17 inquiry report from the BLLRO. Page 16, it is started from page 16.
Page 16 to page 72, all are the inquiry reports. They says, my lord, 5 years back, the recorded lands were in the name of Shorlabala. But after 5 years, on and from 2022, this petitioner, my lord, this accused persons came into effect. My lord, her name came into effect. Because they had forged the version certificate and therefore thereafter they had transferred
Where is
his
that
name.
variation certificate?
My lord, page 72, 73. None.
Version certificate.
70, 73, 74.
Illegible.
But my lord, this both the
We
pages
want
are
to-
illegible.
we-
73, 74.
From where do you know that the signature? Where is the original of this? Where is the main forgery is here?
The version certificate.
Correct. So where is the investigation on this document?
My investigation is going on. It has not yet been completed.
We understand. When did it commence?
My lord, July.
July 2024.
Yes, ma'am.
6 months almost.
Almost.
You have not got possession of the variation certificate?
My lord, it is there, my lord. Page 73, 74 are the version
We
certificates.
are seeing a photocopy.
Yes, my lord.
You
Original.
got the
We have
original.
to
Where
get
is
the original. Yes, my Xerox.
We know, but where is the original? Have you collected the original? From how are you saying that this is a forged document? How are you saying it is a forged document? Who told you it is a forged document? Because it is signed by Panchayat Pradhan, it is forged. Ask the investigating officer to be present with the original case diary, including the variation certificate. Panchayat investigating officer is directed to be present along with the original case diary, as well as the alleged forged certificate on the strength or alleged forged certificate on whose strength the names of co-accused were entered in the record of rights. Monday.
Monday, my lord.
Grateful, my lord.
Next.
May it please your lordship.
को screen करने के लिए
My lord, the case is under sections 341, 354A, 354, 379, 506.
So then, he's honestly get that certificate. The case of corruption. So इसको forgery करवा के इसके खिलाफ में लगा.
My lord, the de facto complainant got married with the petitioner number 1, my lord, in a temple. Subsequently, love lost, though they have applied for registration of marriage, but she did not turn up. And thereafter, this case, I have already annexed the document showing the application form, my lord.
I am for the de facto complainant. Can you see the letter of complaint? All my originals are kept in his custody. I was forced to do the marriage and I was forced to put my signature on the application form.
All right.
Pursuant to that, the
Petitioner
complaint was
submits
lodged.
that
No, my lord,
there was
no whisper of
yeah,
those things.
there was an intimate relationship between the parties and they were living together. He has been falsely implicated. Learned lawyer for the state opposes the prayer for anticipatory bail. Accordingly, opposes the prayer. Learned lawyer for the de facto complainant submits that her original documents were detained by the petitioner and she was compelled to sign on applications for registering their marriage. We have considered the materials on record. While the de facto complainant contends that she had no intention to cohabit with the petitioner, it is the petitioner's case that they were living together as living together, full stop. Applications had been also submitted for registering their marriage, full stop. Under such circumstances, we are of the opinion custodial interrogation is not necessary and petitioner may be granted anticipatory bail subject to conditions. Meet investigating officer once.
Petitioners, my lord.
Petitioner.
Sir, let he return my all original documents, my mark sheet, my admit card.
Your marriage is with petitioner number 1, na?
Yes, my lord.
ওটা petition number 1 হবে, হ্যাঁ? Petition number 1 shall meet the investigating officer once in a week. It is made clear certificates, if any, shall be returned to the de facto. It is made clear petition number 1 shall submit certificates, if any, of the de facto complainant in his possession during the interrogation.
Great.
Next.
Time for the petitioner 406 420.
We are for the state, my lord.
Insurance company he collected the money, partly was deposited, partly no. My lord, he went to the office to deposit the rest. They said that a case was initiated.
Please deposit. Please deposit.
Madam.
Remainder sum he wants to deposit. Petitioner undertakes to deposit the remainder sum.
1,03,000.
Remainder sum without prejudice to his rights and conditions. In light of the aforesaid submission, we direct the petitioner to deposit the remainder, the sum, a sum of rupees 1,03,800 with the learned with the jurisdictional magistrate, and in the event that within 7 days from date, in the event the same is deposited, the learned magistrate shall be at liberty to return the same to the de facto complainant subject to appropriate conditions, subject to furnishing bond as well as result of the case. Copy of the matter will appear 10 days hence.
Grateful, that's.
Next.
For the statement.
I'm for the petitioner, my lord. Over the issue of, my lord, rent of a pandal, my lord, there is a free fight between the parties, my lord. Even we have also suffered injury, my lord.
Well, the cart injury
We
is
went
there.
to lodge complaint, my lord, but that was not registered, my lord. Here is the some medical documents.
All right. We have considered the materials on record. It is contended there was a free fight over the issue of raising our for non-payment of rent
Yes, my lord.
for raising a pandal for marriage purposes. Injuries do
Yes, my
not
lord. Injury report is there, my lord. The cut injury and my lord, the
injuries do not appear to be grievous. Under such circumstances, we are inclined to grant anticipatory.
Let me know.
Next,
Let me.
Crime petition, my lord. Lord, 117, 118, 109, my lord. 325, 326, 307, my lord. My lord, there is, my lord, the dispute with the two parties, my lord, regarding the, my lord, previous branch, my lord. Lord.
The injuries appears to be simple, all named, but my lord, I will,
consider
my lord,
the
one
materials on
respectful
record,
submission, my lord.
including the
There are 4 accused person, petitioner number
which are
3, 5, 6,
simple.
7. Against them, my lord, they are history sheeted. One
Accordingly, we are
302
inclined
is
to
there, my
grant
lord.
anticipatory bail. Hello. Next.
Obliged, my lord.
Service test.
ঠিক আছে দিয়ে দে।
State খেয়েছি লাগে এই তোমার নামটা দাও
I am for the petitioner, my lord. My lord, petitioner is the husband before your lordship.
That's also true. You know, in this matter, I am bringing for day's accommodation because the CD has gone to the wrong council.
Wrong council?
Yes, Mr. Monica Sharma received instead of PC Dadotri.
Then
the Lordship will take it up tomorrow.
Who is he?
He's the husband.
2 co-accused already granted.
Mother-in-law,
executive
mother-in-law.
bail. My lord, I am on the same footing. Petitioner is the migrant labor. At the time of incident, he was in Gujarat.
The uncle-in-law has been granted.
Uncle and father-in-law. Even the, my lord, kindly, if your lordship kindly come to page 32, my lord, the complainant lodge complaint against his own son also, who is, and he granted bail.
Lordship will take it up tomorrow.
Tomorrow, my
Tomorrow.
Deeply.
Wait, Mr. Lordship. For a case of cheating and forgery, well, this petitioner, he is the managing partner of a concern by the name of Srishti Engineer Tech. Now, what had happened, a company by the name of Hindustan Steelworks Construction Limited had issued a tender. We had been successful. Well, thereafter, as per the requirements of the tender, we were to place 3 bank guarantees. Well, we had procured the same since we are from Odisha. We had got it done through a facilitator by the name of SRT Technologies. Now, well, we had thereafter commenced the project also. Well, in the midst, we received a termination notice saying that the bank guarantees were forged. Now,
You were the successful tenderer.
Yes, I was the successful tenderer.
And the bank guarantee was obtained through
one company by the name of two persons, Shovik and
how can you say that the bank guarantee
no,
you-
there is a process, my lord, by which there is a platform on on which it can be verified. It's a Government of India Government of India platform created by the Government of India to verify those.
Well, the only thing is that we had never, there is no allegation that we have failed in our in execution of the contract. If your lordship kindly sees the termination notice at page 61. The only
Whatever. You have used a forged document. We have reason to
we had
believe
done
that.
it through a consultancy company.
You may
But
have done it. The consultancy company does not take the liability of opening a bank guarantee. Bank guarantee means that you had to give some collaterals or you had an account in the bank. Otherwise, a bank guarantee is not available in open market, is it? Then
that is so, my lord. The only thing is that, my lord, there was no reason for the for our principal to even
entire work was founded on the basis that you were to open a
I've
bank.
done the work also, my lord.
You may have done the work. That's another thing.
I've done part of the work. It was never for the on my default that the bank guarantee was to be invoked.
Petitioner contends he is the managing director of a firm which had been awarded contract by Messrs. Hindustan Steelworks Construction Limited, HSCL. He had duly executed the work till the same was improperly till his contract was improperly terminated, which has been challenged in a writ proceeding. He further contends the crux of the termination was the termination was on the ground that he had furnished a forged bank guarantee. The bank guarantee had been obtained through a facilitator, namely through facilitators, namely Bikram Mohanty and Shobik Bhattacharya, and petitioner was unaware that the instrument was a forged one. Accordingly, he prays for anticipatory bail. Learned lawyer for the state opposed the prayer. He contends petitioner had knowingly furnished a forged bank guarantee and thereby persuaded a government company to award contract. His contract was subsequently terminated. We have considered the materials on record. Admittedly, petitioner had furnished a forged bank guarantee on the strength of which he was awarded a government contract. The contract has since been terminated. Full stop. Petitioner's defense is that he had obtained the guarantee through third parties and was unaware that the same is a forged one. This is difficult for us to believe. This defense is difficult for us to believe, as the petitioner would be compelled to, as the petitioner would require to provide collaterals or other financial security to obtain a bank guarantee. It cannot be said that the manner and circumstances in which the forged bank guarantee was procured was wholly beyond his knowledge or control. Hence, we are not inclined to grant anticipatory bail to him.
Perhaps it was a Benami transaction.
So you acknowledge a Benami transaction? You had to give some collateral or financial, otherwise how can there be a bank? Yes.
Lordships, I'm for the petitioner.
Yes.
I'm for the petitioner, your lordships. The allegations have been made under section 341, 323, 326, 307, 506, and 34 of the Indian Penal Code. Alert. There is a dispute between the de facto complainant, your lordships, between the de facto complainant and the rest of the accused.
The materials on record, petitioner is the principal accused who had assaulted the victim. He does not stand on the same footing with co-accused who have been granted pre-arrest bail. As a result of assault, victim's jaw had been broken. Hence, we are not inclined to grant and
My lord, there was no assault made on the part of the petitioner, my lord. Grateful to your lordship.
He's the principal accuser. Next.
My lord, item 65, my lord, I am appearing for the petitioner. My lord, I am online. Your lordship's pleasure would be to kindly come to page 26A of the application. My lord, that is the complaint which is there. My lord, the summum bonum of the allegation is that the lady along with her husband had a property, had a company in fact, and the company had a property. My lord, they decided to, somebody approached them for the purpose of buying of that property, and then they signed a few documents, and thereafter the property became somebody else's, which includes me, and they did not give any money. We did not give them any money. My lord, this is the crux of the allegation. The bottom line is, your lordship would see page 27, paragraph number 6 is what the allegation is. Whereas the issue is that this has happened in 2021. Taking advantage, page 27, paragraph number 6. In the year 2021, Mr. Kalam, accused number 1, introduced himself as officer of your PS and started persuading my husband to sell the factory land, and he would pay 1.5 crores before we could decide anything. On the next day, he came with so-and-so, the accused number 2, who falsely disclosed my husband that he needed signature of my husband to regularize the records of the company as well as the undersigned, as because the records of the register of companies has been shown to be dead persons. Now, your lordship would go to page 28. On the next day, the accused 1, 2, and 5. My lord, I am accused number 3. 1, 2, and 5 started pressurizing my husband to sign on some blank papers instead of signing on the same. Also demanded original papers pertaining to title of the landed factory of the company. My husband refused to hand over the said papers or signing of the papers in absence of agreement for sale, the said landed factory of the company. Then the aforesaid accused persons against falsely persuaded that they will take copies of the originals pertaining to land deed, so-and-so, and they will make Xerox in Ultudanga more, and they shall return. But soon they left, they kept their mobile switched off. And then paragraph number 9, but in spite of old age, my husband contacted Bhaskar Banerjee, accused number 9, above, herein above, through Mr. Sushanto Dasgupta, accused number 8, herein above. But unfortunately, whenever my husband tried to contact him, he started.
1 crore has been transferred.
Alert?
1 crore was transferred.
No, no, my lord. The issue is that it was not 1 crore transferred. I have paid them 30,000 rupees for buying 300 shares at the rate of 10. So that I'm sorry, I've given them 3,000 rupees because what had happened, my lord? There was only 30,000 shares. And I have bought 300 shares out of that. So I have paid the consideration money. The issue is that your lordship's pleasure would be to kindly come to page 13. Your lordship would understand. These are all their signatures. This is happening in 2021. They did not approach NCLT. They did not file any civil suit because they knew they have signed everything, because they took the money in cash, because the husband was unwell and she took everything in cash. See page 13, my lord. This is where the transfer of 3,000 shares is happening. Now, my lord, kindly comes to page 14. This is where Dilip Bhattacharjee signs that he's received the money. Page 15. This is happening in 2021. Date of execution, your lordship would see 9/10/2020 on the top.
Come to page 30.
Page
of
30.
Roman 5.
Page 30.
Say that 1 crore has been transferred to the company in the records. How does that happen?
My lord, after the money after they resigned, my lord, we became the directors. We liquidated their debts. This is happening in 2000, from 2012 onwards, this company was shut. I've pleaded that in my petition. I have gone and complied with the 41A notices. I have indicated everything to the IO. I liquidated the debts. They did not have the money to liquidate their own debts. Everything, my lord, unfortunately, everything happened in cash.
De facto complainant is here.
My lord, I won't know.
Inform the de facto complainant. Officer in charge so and so is directed to notify the de facto complainant with regard to the pendency of the proceeding and his right to participate. Matter will appear 1 week hence.
Deeply oppressed.
On the matters 2 p.m.
Deeply oppressed.
Exclusively, I am for the petitioner.
I'm for the state, my lord.
Allegation under section 498, 304B, 3434 Dowry Prohibition Act. The petitioner before your lordship is the father-in-law and one brother-in-law and the wife of the brother-in-law, my lord. Husband has been granted bail after 92 days in custody, my lord. My lord, all these petitioners will reside in a separate mess other than the victim, my lord. Victim used to reside with the husband, my lord, and she committed suicide with the
How many years after marriage?
My lord, 5 years. There has been an allegation of, my lord, illicit relationship with the husband of with the, my lord, another lady, my lord. This is also, my lord, written in the 156 clause 3 petition, my lord. চুপ কর না।
Petitioners are the in-laws of the deceased housewife. It is contended the dispute broke up between the deceased and her husband over an illicit relationship maintained by the husband. Husband of the deceased has been enlarged on regular bail. Petitioners pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Statements of independent witnesses show primarily implicate the husband in the torture. Allegation against the in-laws, that is the petitioners, are generic in nature. In view of the extent of husband of the deceased is on regular bail. In view of the aforesaid and the extent of complicity of the petitioners in the crime, we are inclined to grant anticipatory bail. আচ্ছা এই 438(2) করবে না 482(2) get of 438(2) হচ্ছে আগের অর্ডার গুলো তো সব 438(2) গেছে মানে ছুটির আগেও যে অর্ডার গুলি গেছে সব 438(2) গেছে
I am for the petitioner. The allegation under section 120B, 420, 467, 468, 471 of the Indian Penal Code. And the allegation is that in the year 2014 and 15, the petitioner along with other 38% took loan from the bank by forging document.
Now, they have sought for car loans. There's a case of 2018. One of the application loan form says it's Swift Desire. The real document shows.
Have you repaid the loan?
No. Total amount involved is above
Petitioner
crores.
contends that the dispute arose out of a commercial transaction. Allegation of submitting forged document is false. He prays for anticipatory bail. Learned lawyer for the state opposed the prayer. He contends that petitioners had used forged document to obtain loan to purchase a commercial vehicle. Subsequently, he has failed to repay the loan. We have considered the materials on record. Petitioners had fraudulently obtained loan to purchase vehicle. He failed to repay the loan. Criminal case was registered in 2018. Thereafter, he had absconded. Keeping in mind the aforesaid circumstances, we are of the opinion custodial interrogation for progress of investigation is necessary, and this is not a fit case to grant anticipatory.
Grateful, man.
Next.
First, I'm seeking for not today.
Why?
Senior engaged in the matter is arguing the matter in court number 32.
But you are engaged before us.
My lord, the injury report, my lord. ঠিক আছে আমি বলি my lord.
There is.
My lord,
498 and 406.
Yes,
I'm for the factors of criminal.
307. Because the injury report, in spite of, my lord, will kindly see the injury
By
report.
307, not 307.
Yes.
It will 109.
109. My lord, will kindly see the two paragraphs Second and third paragraph. একটু my lord
Where is the injury report?
Oh, my lord, second and third paragraph.
I'm for the de facto complaint, madam, and subject to
I
correction. it
request
doesn't
some
have
time,
the-
my lord. দাঁড়ান, দাঁড়ান, দাঁড়ান। পড়তে দে, পড়তে দে। My lordকে পড়তে দে।
Petitioner, we have considered the materials on record. Allegations of
Started date.
torture are general and omnibus. Stridon articles have been seized. Allegation of attempt to murder. It is alleged that petitioners pressed pillow on the face of the victim to commit in an attempt to murder her. Full stop. Credibility of the allegation may be assessed during trial. However, custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant answer.
Much obliged.
Next.
Article 69, I'm for the petition, lordship.
Minute, I appear on behalf of this.
What is the injury?
Minute, the injury is severe, but the involvement of the petitioner is this. They tried to strangulate with the sari. She is a lady.
So let us see.
I have highlight.
Now let us see the injury report.
I have kindly unfold the page. He was admitted for 4 days. 2nd 11 to 6th 11. Cut injury over face with knife and rods.
Petitioner content, she has been falsely implicated. She prays for anticipatory bail and a lawyer for the state opposes the prayer. We have considered the materials on record. Victim stated petitioner had tried to strangulate her with a sari. Injury report shows injuries in her injury report notes that there was injury report notes that injuries were due to knife or wooden stick. This improbabilizes the allegation against the petitioner. Accordingly, we are inclined to grant answer.
Okay.
Next.
I am for the petitioner. I have submerged. Allegation is at the time of the Salish was going on that one Nurul Islam shot fire at Komol Rajvanshi and was expired at that time. In connection
It's a case of 2021. The co-accused standing on similar footing with this petitioner, 38 has been rejected by this Honorable High Court.
Statements of witnesses. We have considered the materials on record. Statement of witnesses show petitioner was present at the spot and actively connived with co-accused who had fired at the victim, resulting in his death.
Yes.
Resulting in his death.
Death, no.
Resulting in
326,
life-threatening injuries. Prayer for anticipatory bail of co-accused has been rejected. Under such circumstances, we do not find any merit in the application, and the same is. Next.
May I please, Your Lordship? The petitioner is the wife of the alleged victim, Your Lordship, who himself said ablaze. At the time of occurrence, she was, after 10 years of marriage, this alleged incident happened. He happens
Husband committed suicide.
Husband committed 10 years.
Death by burning.
Husband. 10 years after marriage, Your Lordship, she was in duty at that alleged time. At that alleged time, she was in duty as a BSF.
The allegations of the neighbors are that she was having an
Prism.
Petitioner is
Yes, sir.
a member of
BSF.
the armed forces. Her husband suspected her involvement with another colleague. He committed suicide. She has been falsely implicated. She prays for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Statements of witnesses show support the petitioner's case that her husband committed suicide. Full stop. In view of she was not present at the spot. In view of the aforesaid facts, we are of the opinion petitioner has made out a case for grant of anticipatory bail. Allowed.
Published, Your Lordship.
Next.
Right. Over the self-serve incident, the two case and counter case has been
Like 77, I am not placed.
77.
77. 77, I am the petition I am praying for not placed, my lord. I am praying for not placed as usual.
Next.
স্যার আমরা দিয়ে দিচ্ছি স্যার আমরা দিয়ে দিচ্ছি
Sir, I am for the petitioner. 118.2 and 109, that is 307 and 326 of the Indian Penal Code. Case and counter case between neighbors over a disputed property. This is the counter case. This is 510. Our case is 511. Two brothers are before your lordship. Rest the other family members are on bail.
My lord, 2%, the petitioner over here, they are the principal assailant. 5% total, my lord, injured, out of which 2%, Buddhadev Mandal and Shunil Mandal, their injury appears to be grievous. My lord, 4% was namely the principal assailant over here, 2% before your lordship, 2% didn't come. And regarding the anticipatory bail was allowed, the lady members of the family.
Is it a grievous injury?
My lord, the injury report appears to be, my lord, grievous. One person fracture in one hand, and other person, he was referred to an orthopedic surgeon, 47 and 48. Buddhadev Mandal and Shunil Mandal. And Shunil Mandal was, my lord, admitted for 3 days in the hospital.
Sir, we have considered the materials on record, including the statement of the victim and the injury report. Statement of the victims disclose involvement of the show petitioners had assaulted them with dangerous weapons. As a result, they suffered fracture, injury, and hospitalization. They do not stand on the same footing with female accused who have been granted anticipatory bail. Accordingly, we are not inclined to grant anticipatory bail.
Great, my lord. Deeply obliged. Deeply obliged.
Thank you. My lord, BSF personnel, my lord, apprehended one person and recovered 37 pieces of mobile phone along with 50 bottles of fentanyl. Accordingly, a case was registered against 20%, my lord. I was not in the FIR name. Subsequently, my lord, charge sheet filed. In charge sheet, my lord, 20% has been, my lord, discharged from the charge. My lord, 18% has been, 20% has been discharged from the charge sheet. 2% has been, my lord, as accused in the charge sheet. One who was arrested earlier, my lord, and my name transferred during investigation as a co-accused statement. This is my involvement.
We have considered the materials on record. Petitioner is one of the members of the gang who were dealing in narcotics at the international border. They had confronted, they were confronted by the BSF personnel, and some of them had
My lord, I was not the case that I fled away, or my lord, I was there. The person
He used to employ the people, my lord, to take the consignments, my lord.
the statements are there.
My lord.
Acha.
The co-accused statement.
Co-accused statement, my lord, charge sheet filed.
And my
Neighbors,
lord, the drugs were also
local people,
total number of witnesses.
local people.
Local people, my lord, not examined, my lord. Local people, no, my lord. My lord, the investigation is going on, my lord.
No, charge sheet filed. I have annexed the charge sheet.
Not examined, my lord.
I have
Only
annexed the
police
charge sheet.
witnesses.
10 witnesses is there.
10 witnesses, my lord.
Let us see. They were apprehended at the international border. Full stop. Why you have asked for discharge of others?
20, page 9, my lord, the charge sheet I have annexed. Page 9. 2% FIR charge sheeted. 1 FIR name, what not FIR name, 20 discharge, 18 discharge. 20 discharge. Number of accused person not charge sheeted, 20.
My lord, from the co-accused statement, my lord, this is, my lord, it statement that has come, my lord, that this is the person who was one of the persons who were appointed by this petitioner, my lord, to carry the consignment.
Right. Why these people were discharged?
My lord, the last page, my lord.
Why these people were discharged?
This, my lord, I don't have instruction. May I take instructions, my lord?
Yes. See the
My lord, the
area
charge
we-
sheet, my lord, at the end.
see where I have marked.
My lord. My lord, my lord, इसकी, my lord.
Is that BSF person interrogated?
Are you? No, no, no. In the yes, a person. No, my lord. And may I take instructions, my lord?
Yes, take instruction why your officer shall not be suspended. Right?
My lord.
We are transferring this investigation to a superior agency and we are rejecting your anticipatory. Give the case date. Don't use the process of investigation to obfuscate truth.
Videography तो है ना.
Kato, petitioner contends he is no way connected with trafficking narcotics. He was not present at the spot when BSF personnel apprehended one Dilawar Sheikh with 50 bottles of fentanyl. Full stop. He has been, though first information report was registered against 20 accused, including Dilawar. All of them, apart from the petitioner and Dilawar, have been discharged. Full stop. He prays for anticipatory bail. Learned lawyer for state produces the case diary. We have considered the materials on record. We have gone through the written complaint lodged by SI Ishwar Singh, a member of the raiding party attached to BSF. In the written complaint, it is alleged that BSF personnel had chased 12-13 Indian nationals who were trying to smuggle illicit material. Some of them fled and 3 plastic sacks were recovered from the spot. Some of them fled, but while one of them could be apprehended, others fled. Plastic sacks were recovered from the spot. 50 bottles of fentanyl was recovered from the sack. Paragraph 4 of the first information report notes the de facto complainant, on questioning the apprehended persons, had notes that the apprehended person had divulged names of the
Page 46, no? What's different? 46, my lord, page 46.
কি বললাম? Person had disclosed the involvement, disclosed the names of persons who had apprehended from the spot. Paragraph 5 of the complaint shows of the report also discloses the vital role of other accused, including the petitioner who facilitated the investigation. In spite of the aforesaid incriminating material in the first information report, it belies logic how the investigating agency could pray for discharge of the said accused who were named by the informant. The informant, no further statement of the informant or his associate or his informant or no further statement of the informant, no contrary statement of the informant is placed on record. The investigation smacks of collusion and and divulges an effort, a probable effort of screening offenders. Under such circumstances, we are constrained to direct further investigation in the matter by the
Independent witness name.
by special task force. You got the STF attached to West Bengal Police?
Yes, my lord.
By officers of the special staff force, further investigation under the supervision of the Additional Director General of Police, CID West Bengal, through competent officers not lower than the rank of additional superintendent of police. Full stop. Keeping in view the involvement of the petitioner in facilitating the crime, and as we have directed further investigation which into the matter which would require his custodial interrogation in a grave offense involving smuggling across international border, we are not inclined to grant anticipatory bail. Report with regard to ADG CID shall submit report with regard to commencement of with regard to further investigation on the adjourned date. Matter will appear 2 weeks since. Copy of the order be communicated to ADG CID. Next.
In this matter, service upon the victim is not completed.
No,
81, I
I'm
am
for
for
the
the state
petition.
also. I have received the CD today also. I am free from not today only.
This offense?
325, 323, 307. That have been submitted. That have been submitted.
Injury report lordship 42
The boy
44 lordship.
went to the tennis match. There he received injury. The complaint has been lodged by the mother.
Where is the victim statement? You surrendered. You were assaulted, hospitalized, again hospitalized. Petitioner submit he has been falsely implicated in the case. Incident occurred in the victim was inebriated and an incident occurred in the course of a certain fight. তারপরে বলো petitioners have been falsely. Learned lawyer for the state opposed the bail prayer. We have considered the materials on record. Statement of the victim of the injured show that he was assaulted by the petitioner while he was returning from a match. He was found lying on the road and hospitalized. After release from hospital, he again ill and had to be re-hospitalized. In view of the aforesaid materials on record and gravity of offense, we are not inclined to grant bail. Next.
Right. Make resolution. But this is under 21 small c and 29 of the NDPS Act. But in 3 hours of night on 1st September 2024, pursuant to prior information, at a place called Deep Media and near a fishery, not a vehicle was intercepted. 2 persons were found in the vehicle and a huge quantity of Codin phosphates were recovered from the vehicle. Those 2 persons are Shantanu Bishwas and Milan Rai. When they were interrogated, they said they have procured this contraband article as per for the petitioner and those will be transported to Bangladesh. To whom it will be transported to Bangladesh, nobody knows. So the foundation of the allegation against the petitioner is the statement of the co-accused. Nothing more, nothing less. Our argument should be petitioner is not the owner of the vehicle.
Yes.
This is the co-accused statement, my lord. This petitioner is also named in FIR, and my lord, his implication has been mentioned in page 11.
Correct.
That is right.
There is a specific batch number given. To whom was this batch number sold?
No, that is not there. This is the statement.
That is a lazy investigation.
My lord, that I have to.
Who is the person to whom this is a manufactured drug? The manufacturer has a batch number. The batch number was definitely sold to someone. And this is the person to whom the batch number was supposed to go. Now, how does it come in the hand of this accused? So first, you must know that who is the person to whom is supposed to have gone or had actually gone and then got diverted. Right? So where is that investigation? You want further investigation and give us charge sheet has been filed?
No.
Give us those particulars. 1 week. Investigating officer is directed to submit report with regard to the identity of the person to whom the identity of the dealer to whom the contraband articles bearing batch number TVHW0644 had been sold. He shall also trace out the manner in which the said consignment was diverted from bona fide medicinal use for drug trafficking. 1 week.
1 week.
I am for the petition. Allegation under section 126 to 117 to 118 to 119 35 of the Bharatiya Naya Sanhita. 35 both the party members.
This is
Some injury both the parties.
This is grievous with dangerous weapon. This is attempt to murder. This is common intention. And 126(2) will be wrongful restraint. Yes. Injury.
My lord, before injury, my lord, false statement has been made in the paragraph 1, my lord.
What?
They have made an application for anticipatory bail before the learned court below, my lord. Kindly see the order itself. 5 persons, my lord. Out of 5, my lord, there are 6 persons. Out of that, my lord, 4 persons applied before the court below, my lord. 5 persons. But that is the order to the
We have considered the petitioner contends that They have been falsely implicated in the case. They pray for anticipatory bail and a lawyer for the state submit. Petitioner have preferred an application for anticipatory bail before the sessions judge. He has suppressed such fact before this court. Yes, what do you say?
My lord, not press and withdraw. Not press and withdraw, my lord. Never knows the he file or not. Learned court below, my lord.
Learned counsel submits that he had been the clients had misled him to file the present application. He prays to withdraw the application. Accordingly, dismissed as not pressed. Next.
And then answer the petitioner. Well, the petitioner is a day contract labor. The husband of the defector complainant, Aijul Sheikh, he works under this petitioner. Now, my lord, this Aijul Sheikh took 85,000 rupees from the present petitioner for supply of some labor and some other works. Now, upon asking for the money, my lord, this false case has been lodged against the present petitioner.
Where is Aijul?
He has been recovered.
Yes, recovered, my
No, no, this is the 164 statement of the. He was taken to various places. The call detail says that assaulted. He somehow managed to escape.
Petitioner submits that there were that he has the de facto complainant owed money to him. He has accordingly he falsely implicated
De facto complainant's husband.
De facto complainant's husband Aijul Sheikh owed money to the petitioner. Accordingly, he has been falsely. Accordingly, petitioner has been falsely implicated. He prays for anticipatory bail. Learned public prosecutor opposes the prayer. We have considered the materials on record, including the statement of the said Aijul Sheikh. From the statement, it appears that Aijul had been abducted and confined. However, confined, but he was not recovered by police. Possibility of false implication owing to prior monetary transaction cannot be ruled out. As the missing person has already been recovered, custodial interrogation for progress of investigation is not necessary. Under such circumstances, we are inclined to grant answer.
Obliged, my lord.
डीलिंग करके आ गया है दूसरी बात
My lord, I am for the petitioner.
In time inform. কি হলো আবার? Appellant is not appeal admitted, issue usual notices, call for record, liberty to pay for suspension of sentence upon notice to the state.
My lord, I am for the appellant. My lord, I am challenging the order of acquittal. Appellant is the victim guard. And my lord, charge was under section 376 of the Indian.
My lord, in this matter, I am appearing on behalf of appellant, my lord. My lord, today I am praying for some time, my lord.
Why?
Yes, my lord. Appeal has already been filed, but Section 5 filing is pending, my lord. Appellant lives in Jharkhand, my lord. Till now, he failed.
Adjourn 2 weeks. Necessary steps be taken. Appeal is barred by limitation. Next.
May please, Your Lordship. A conviction under section 302/35, my lord,
Admitted
delay
issue.
of 132 days.
132 day. Miss Das appear. Oh, Miss. Her learned counsel for the appellant as well as Miss Sinha. Senior government advocate.
Additional public prosecutor.
Additional public prosecutor. Being satisfied with the above mentioned application for conditional delay condone, issue usual notice to call for records, liberty to pray for suspension of sentence upon notice to the state.
Right.
Next. Now उसको हुआ है दिवाली को पता है husband. Apply for.
Lordship convicted under section 498A30.
Admitted. Issue officers call for records, liberty to pray for suspension of sentence upon notice to the state to public prosecutor.
I know.
Dilution. Yes.
Well, 95, I am for the appellate's mallet, conviction under 302, 30, 324, 325 for the Indian Penal Code mallet. Appeal has been filed within time. Mallet.
Admitted issue not say accord. Same out. Next. Pending.
Yes, Your Honor, I am for the appellant, convicted under 20B, 2C, and 29 of NDPS Act. I am for the appellant, convicted in under section 20B, 2C, and 29 of
Conviction
NDPS.
by NCB or state?
Huh?
State or NCB?
NCB.
NCB.
Oh, state.
State. Sure.
Yes, versus state of West Bengal.
Versus state of West Bengal. All right. Admitted issue usual notices, call for records, liberty to pray for suspension of sentence upon notice to the state through public prosecutor.
I'm appearing for the appellant, my lord. There is a delay of 996 days.
996 days.
So 302, my lord.
Call for records. No admission. Records will dispose of. 4 weeks.
4 weeks.
Cosmetic appeal for suspension of sentence will not be allowed. We can't stop you for condonation, but we'll stop you from admission.
May it please your lordship. My lord, I am appointed by High Court Legal Services Committee to prefer this appeal.
Very good.
My lord, the appellant was put on trial on a charge.
All right. Admission. Victim notify.
No, my lord,
372
370. 366B and 370.
All right. Admitted, issue usual notice, call for records, liberty to pray for suspension upon notice.
Deeply obliged.
Delay কোথায়? Section 5 নেই, but not in time. Oh. Who is appelled? Legal Services Committee? Anyone there? High Court Legal Services? Tina, Ms. Mitra is requested to High Court Legal Secretary High Court. Nobody appears for the appellate. Secretary High Court Legal Services Committee is directed to appoint Ms. Mitro as counsel for the appellant to prosecute the appeal. Necessary steps be taken. Adjourn 2 weeks. See who is there. Someone's filed the appeal.
Yes, my lord.
They don't appear. They just find out, Miss Mitro. Just tell them first if they are willing. Very good.
কে ফাইল করেছে অ্যাপিলটা?
Miss Minal Sinha has.
Minal Sinha, yes.
Miss, then you inform Minal.
My lord, I will inform.
She will adjourn 1 week.
Adjourn one. Well, I will inform.
Please inform. কিছু কোনো adjourn 1. Next.
My lord, I am for the appellant, my lord. Conviction under section 21C of the NDPS.
Lordship, I am praying for not today only.
For what?
Lordship, I missed the beef.
What?
I missed the beef today, Lordship.
You are?
I'm for the state, Lordship. I
Very
missed
good. How many days delay?
92 days delay only.
Delay condoned. Appeal admitted. Issue usual notices. call for liberty to pay for suspension of sentence upon notice to the state. Call for records. Next. Service for this? 101. Yes.
Sir, but I for the appellant, blood.
Exactly.
Delay blood of 126 days blood.
Huh?
There's a delay blood.
How long?
126 days.
126 days. Yes. Vivasan Bhattacharya appear.
That corona.
Vivasan Bhattacharya is directed to appear on behalf of the state. London Public Prosecutor is requested to regularize his appointment. Copy of the application is served upon him. Having considered averments, delay condoned, appeal admitted, issue usual notices, liberty to pray for call for records, liberty to pray for suspension of sentence upon notice to the state. Next.
Asham for the appellant, Lordship. I was convicted under section 302, Lordship, imprisonment for life, Lordship, 200.
Condonation, how many days?
255 days.
Huh?
255 days.
255 days. Ms. Das appear. Ms. Das, learned advocate for state, is directed to appear in the matter. Her appointment be regularized. Having considered the averments, delay is condoned, appeal admitted, issue your usual notices.
102.
Liberty to pray for call for records, liberty to pray for suspension of sentence upon notice.
Grateful, Lordship.
Next. Acquittal. Having considered we have considered the impugned judgment as well as the grounds of appeal. Appellant has made out an arguable case in appeal. Appeal is admitted. Issue usual notices, call for records. Respondent number so and so. Within fortnight from receipt of notice of appeal, respondent number so and so shall appear before the trial court, and upon appearance shall be released on bail to the satisfaction of the trial court till disposal of the appeal. Next. Jail. Miss Sen, you are in the High Court Legal Services Committee? Huh? You are not. Vibhashwan, you are there in the High Court Legal. You appear. Mr. Vibhashwan Bhattacharya is requested to prosecute the appeal on behalf of the appellant. Secretary High Court Legal Services Committee shall regularize his appointment. He is directed to take necessary steps. High Court Legal Services. এই দীপাঞ্জন দত্ত, হাইকোর্ট লিগাল সার্ভিসেস কমিটি, appear. Same order, huh? Dīpanjan Dutt. Yes, next matter. Shatadru Lahiri.
Relaxation.
Yes. Relaxation of what?
Well, the condition of not to enter within the jurisdiction of the
Of what?
of the police station, millet.
Of what?
438.
For?
The condition granted on 438, millet.
So where is the scope of relaxing that condition which does not exist?
Millet.
The condition of bail, condition order of anticipatory bail is subsumed in the order of regular bail. Accordingly, it is open under such circumstances, the application for relaxation of condition of anticipatory bail is not maintainable.
Millet, kindly, earlier I preferred a relaxation. At that point of time, it was rejected on merit. At that point of time, millet, this court did not interfere on the premise that the trial was not continuing.
But we don't understand how can we, this bench, have jurisdiction. You have to apply before the bench having power to relax condition of regular bail.
But I have surrendered before the court.
Correct. That is why we are saying if you had not surrendered, yes, we would have understood. We would have understood modifying our condition for direction to appear and pray for regular bail. But once you pray for regular bail and the conditions envisaged become a part of the order of regular bail, it's a relaxation of that order of regular bail, which is under 483 subsection 2. And it goes to the other bench. Right.
And since that bench also, since the original order is under section.
Where is the original order? We would have, yes, we understand that even if the regular bail is granted by the magistrate or the sessions judge, you may feel, since the condition was imposed by the High Court under 438, it may embarrass the sessions judge or the magistrate, approach the High Court. The power of the High Court to relax an order condition imposed by magistrate is already there. How can we relax a condition in an order which is no longer existing? The order is, every order of anticipatory bail is a transient one. It gets subsumed in the order of regular bail. Conditions indicated become engrafted into the order of regular bail. You seek the modification of that condition which is existing today.
I have annexed that order.
But do we have jurisdiction? We have jurisdiction to relax regular bail orders. কি বললাম যেন? Under such circumstances, the application is for relaxation of condition of bail and not anticipatory bail. Hence, the matter is released from our list. Let it be placed before the bench which has power to relax regular bail. To regular bail, if the magistrate
My lord, 107, my lord, I am for the applicant. My lord, I am seeking correction of the order dated 27th February. My lord, this petitioner, while granting PRS bail, was directed to make a payment of 25,000 per month. My lord, subject to the quantum is decided by the learned magistrate. Thereafter, the opposite party wife took out an application into a proceeding under DV Act. My lord, she lost there. We moved an application for relaxation. My lord, here the order is modified. My lord, for once, comes to page 9, the order.
Your Lordship, Ms. Zareen Khan is appearing in this matter. She is not present today due to her health condition.
No, where is the victim? Please inform, intimate Uday. Uday Shankar. Please.
Yeah, no, he is not appearing. Uday Shankar is no more appearing.
What do you mean to say?
We have already intimated.
Yes, Mr. Chattopadhyay.
আগে ছিলাম
হ্যাঁ
ওই সেই ম্যাটারটা তো
Will you take instructions?
ভালো
Will you, if you appear, then you take instructions.
My lord, only correction I seek is at page 11, paragraph 3. Subsequent starts with subsequent to the order. My lord, in the last sentence, the appeal therefore is yet to be admitted. My lord, on 16th it got admitted. On the next day, we were informed that it is admitted. I have annexed the order.
What appeal?
Page 16. My lord, appeal against the dismissal of the DB proceeding.
You are for whom?
I am for the husband. My lord, page 16 is the order where the appeal was admitted. My lord, we have informed this honorable court that appeal is yet to be informed. That has been recorded. Only correction we are seeking. Page 16. Oh, এই order my lord কে দেখিয়েছি। My lord কে দেখিয়েছি।
So the order is that you need not pay any maintenance.
Yes, no, my lord, only page 11, the third paragraph, which starts with subsequent to the order, is the last sentence. My lord, there is a recording that appeal therefore is yet to be admitted. Page 11, the order of this honorable court.
But fact is that time appeal admitted.
Yes. On 27th February, this was submitted
Wrong
by
submission.
us.
Again,
wrong submission.
Anything.
Appeal therefore is yet to be admitted.
Admitted. This,
But
my lord,
that-
this order was passed on 27th February.
So we'll correct that.
Yes, on 16th
But then it
February,
should be
that
placed
was
before
only
the
this part.
appropriate, the bench presided by Justice Boshak. You seek correction of that order, na? What the petitioner seek correction of order passed by a bench presided by Justice Devanshu Boshak. Under such circumstances, matter is released from our list. It is open to the petitioner to seek assignment before the appropriate bench.
Wait.
Yes.
Please, my lord. My lord, order at page 17, my lord. I am requesting for
We are-
relaxation.
we are
The
appearing
conditions
for-
are at page 19, my lord.
This page.
My lord, this original FIR was in March 2023, re-registration in May, and my lord, subsequently, my lord, I was arrested in February 2024. And my lord, there is no bone injury, nothing of that sort, my lord. And subject to correction by your lordship, my lord, this appellant is concerned, he was not named in the FIR of March 22, I mean March 30th or even my lord, February to May 10th, 2024. And my lord, conditions are at page 19, my lord. I've been complying with, my lord.
My lord, we are appearing for the NIA, my lord. This is
Uh-huh.
practically, my lord, for relaxation of condition of bail.
It has to go before the regular.
This is an order in an appeal. Under
Yes, oh,
21.
yes, but that is nomenclature is that, my lord. But in essence, my lord, relaxation of condition of bail, which was granted by a court bench of this honorable court, my lord.
No, no, why? This is Bakshi
So, my lord,
sitting in different combination only.
This is an appeal.
Yes, my lord, that.
So we have the power to entertain appeal.
My lord,
Well, a similar issue has risen because of anticipatory bail and regular bail. Well, since this has been treated as an appeal and it is relating to the grant of bail or refusal of bail, well, that court released the matter and when your lordship was taking up regular bail matters. So now this anticipatory bail is your
Let
jurisdiction.
it be placed before,
Before
but
the
even
regular-
now we have that jurisdiction.
Absolutely.
Now
And in any case, this is an appeal. This can be by the court which passed the order, my lord.
We made a mistake. Please inform Shatudru Lahiri his relaxation of condition
Right,
will
my lord.
consider.
Your lordship is right.
Mr. It slipped off
I'll
mind that
inform
we
you.
have the
I'll
urgent
inform you.
jurisdiction. ওই আগের যে রিল্যাক্সেশনটা আছে না ওই বলেছি অ্যাপ্রোপ্রিয়েট বেঞ্চ ওইটাকে নট টুডে করে Yes, what is the condition?
My lord, page 19, my lord. Paragraph 7.
The big condition, how much you want? You want to intimidate witness?
No, my lord.
Then what do you want, Taylor?
My lord, that I will enter
You
the
will enter
jurisdiction,
what?
my lord, because my lord, my home is there. Number 2, my lord. Kindly see, my lord, if
All
I
right,
may just...
let them give a report.
Yes,
My lord, I have filed other my lord, documents, my lord, that I have been
Let them
complained.
give a report.
we will file a report, Milord.
Monday. Report on Monday.
On Monday, but most obliged.
Wednesday, what?
Milord, would be Lordship's pleasure to take up this matter Wednesday, Milord. Milord, Milord,
No,
IOs are there.
we are kind enough to give you Monday.
Yes.
There has been sufficient time he has been kept out of Calcutta.
Most obliged.
Yes, next matter.
Well, this is my application for relaxation of condition of bail in respect of the anticipatory bail. My lord, the condition was to appear before the investigation officer in a month of till the conclusion of the investigation and further condition that the
Yes.
petition.
Who is there?
Yeah, that is not submitted.
But has he complied?
My lord.
Complaint.
Has he been released on regular bail?
Yes, ma'am.
Where is that order that you have been released on regular bail?
My lord,
Huh?
my lord, page, my lord, 9, my lord.
Okay. Petitioner has complied with the condition of anticipatory bail / regular bail according to the condition of anticipatory bail / regular bail to report to officer in charge, investigating officer once in a month till conclusion of investigation. Is in view of the nature of investigation, we are of the opinion further attendance for purpose of investigation is not necessary. Accordingly, condition of bail so and so is waived. Other conditions shall continue.
My lord, there is another condition is there, my lord. There is another condition, my lord. The petitioner shall appear on every date before the judicial court. My lord, through my lord, the learned advocate, my lord.
Next.
My lord, 110 is my application, your lordship. There is an application under section 42 of the Prevention of Money Laundering Act, my lord, directed, my lord, against an order passed by the appellate authority under section 26.
Yes.
Yes.
Where is Bhaskar Banerjee?
No, your lordship, Mr. Vipul Kundalia was appearing for the, my lord, enforcement authority.
Where is he?
He's not there. If your lordship pleases, I will inform him once.
Inform him.
Your lordship kindly fixes a date subject to your lordship's convenience.
Every day is a date, sir.
Very well. I'll come back tomorrow.
Ask him to be present tomorrow.
Very well, man. I'll do that.
So how is it? What relaxation you want?
No, my lord, I do not want. My lord, my property has been attached by the order. My lord, the property attachment order which was confirmed by the adjudicating authority against the order of the adjudicating authority. I preferred the appeal, which was dismissed. So here, my lord, under section 42, I am challenging that order of the appellate authority.
Second appeal.
Yes, your lordship.
So this cannot come in the form of an application. How is it coming from an application? How is it coming in the form of
So,
application?
my lord, an application for stay was filed along with the, my lord, memorandum of appeal.
Let us dismiss the stay. We have considered the materials on record. The order impugns.
No, my lord, only one aspect of the matter, my lord. May I? May I come back tomorrow, your lordship? My lord, let Mr. Kundalia be there.
All right.
Very well. Deeply obliged, your lordship.
Well, this is also my application for relaxation of bail, my lord, condition of bail, my lord.
Why?
Yeah, surrendered and murdered.
All right. We have got appropriate bench jurisdiction now. Huh? Then let us not be so finicky, all right? They will only burden the other bench. All right.
Yes, complied.
Complied to yak order, waived to meet once in a month.
Right.
Or the report may be kept to the
Sanjana?
My lord, the petitioner has been granted regular bail.
All right. So we have jurisdiction to relax regular bail also today.
My lord,
Yes,
please to
Mr.
grant
Dotto.
pre-arrest bail, my lord, by order dated
What
9th
is
of
the
April.
condition?
That's at page 21, my lord. The condition, my lord, is twofold. One is to surrender within 4 weeks, which we have
All
done, my
right,
lord.
give notice to victim, de facto complaint.
My lord, this is a 406-420.
But they appeared, na?
My lord, they appear. My lord, the condition is at paragraph 8, my lord.
All right, give notice. Day after tomorrow.
I'll
Notice
fetch
to the
report as well.
officer in charge shall give notice to the de facto complainant. Matter will appear day after tomorrow.
Deeply obliged.
Next. Data. 1 second, Mr. Chatterjee. Yes, modification. What was your condition?
My lord, there was a local security, my lord. He failed. This lady failed to, my lord, arrange the same.
All
In
right.
August, my lord, I have filed this application.
Petitioner is unable to arrange local surety. As a result, he could not appear and pray for regular bail. Under such circumstances, we modify the condition of anticipatory bail and direct that in the event of his arrest, he may be released on bail upon furnishing a bond of 10,000 rupees with 2 registered sureties of like amount each to the satisfaction of the arresting officer. Other conditions of bail shall continue. Petitioner shall appear before the jurisdictional magistrate and pray for regular bail within 4 weeks from date.
Grateful, my lord. Deeply.
Next.
My lord, same, my lord, 140 manner instead of local security, registered security.
For Uday Chatterjee, no. Oh, same for 150. Same order, same order.
Same order. Grateful, your lord.
Where is elder brother?
My lord, today is in Calcutta, my lord.
Huh?
Today, my lord, is in Calcutta, my lord.
Today is in Calcutta. You have stopped his coming to Calcutta
No,
also?
no. My lord, yesterday, my lord, he went to native village.
Native village. Everyone is afraid of him. Entire family has run away to village. Next.
My lord, I am for the respondent, my lord.
Yes.
16, my lord, 16 and 17. Both I am for the respondent, my lord. The copy was not served us. We are seeing the costly standing for the respondent, my lord.
I will give my today. I am or not with my brief, my lord.
Day after tomorrow. Day after tomorrow. Copy will be given to you by tomorrow.
Deeply obliged, your lordship.
Copy of the application for relaxation of condition of bail be handed over to learned lawyer for the de facto complainant by tomorrow. Matter will appear day after tomorrow.
16 and 17.
16 and 17.
Grateful, man.
Deeply obliged, your lordship.
Next.
This is my application, Lordship, regarding the modification, anticipatory bail regarding the pilferage granted on 15/7/2024. Within time, we have paid the 50% amount deposited with the licensee. That is, Lordship will find page 10. And what happened, my lord? Within 2 weeks, we have to surrender. We surrender, but the local we cannot arrange because they, due to the satisfaction of the learned CGM.
Petitioner submits. He has not been able to arrange local. He has not been able to arrange local surety. As a consequence, he could not pay for regular bail within time, within the stipulated time. Under such circumstances, condition of anticipatory bail is modified and it is directed in the event he is arrested, he shall be released on bail on furnishing a bond of 5,000 with two sureties of like amount each to the satisfaction of the arresting officer.
Only studio local deleted.
Other conditions shall remain the same. Petitioner shall appear before the jurisdictional court and pray for regular jurisdictional special court and pray for regular bail.
Within a period, my lord,
Within 4 weeks.
My lord, I am getting. Yes, sir.
My lord, this is my application, my lord, for relaxation of the condition of the bail, my lord, that was granted on 6th August. Now, on the second page of the order, Lord, you will find there was a direction to meet the investigation officer once every week. Since then, my lord, I have been complying with that order.
He has complied, your lordship.
Petitioner has complied with the condition of bail / regular anticipatory bail / regular bail. Further attendance before the investigating officer for purpose of investigation is not necessary. Under such circumstances, we modify the condition of bail, condition of anticipatory bail / bail, directing him to meet investigating officer once in a week till submission of final report. Have you appeared before the regular court and taken regular bail?
Yes, my lord. My lord, 6th August, I obtained the
Alright.
anticipated bail. 9th August, I had surrendered. Grateful, my lord.
My lord, I am for the petitioners. My lord, the matter was settled between the PAC and the petitioners. Drill the matter.
Not pressed. Next.
And I'm for the petitioner.
I'm for the statement.
121. My lord, petitioner unable to arrange the local surety, my lord.
Petitioner is unable to arrange local surety. As a result, he could not appear before the jurisdictional magistrate and pray for regular bail. Under such circumstances, we act. Bond of 10,000 with 2 registered surety. Other conditions shall remain the same. Petitioner shall appear before the jurisdictional magistrate within 4 weeks from date and pray for regular.
I'm good.
Next.
My lord, I was
Regarding item number 166, it has come under the wrong heading. Cancellation of bail. This is an application for anticipatory bail.